The gate agent looked at the screen and then looked back at the passenger. No words, just a pause that lasted too long. A suspension that U.S. immigration officials had flagged, border agents had escalated, and airline coordinators had scrambled to contain. A sudden ping on a departure board, a bright red status change where green used to be, an overwhelmed check-in desk asking questions that sound administrative but carry life-changing weight. This travel disruption didn't unfold over months. It unfolded in hours. Hours that could strand you mid-journey. Hours that could trigger a secondary inspection on your return. Hours that could put your U.S. visa status under a microscope you never expected. One wrong move here, and you could be on a flight back home tomorrow with a stamp in your passport you never wanted. What triggered this suspension crossed a threshold that aviation authorities and U.S. Customs and Border Protection hoped would hold. And when that threshold cracked, the response from multiple agencies was not slow. They moved with speed, coordination, and a severity that caught even frequent travelers off guard. Most people panic in this moment. They book the first alternate flight they find. They make the same mistake. They fall straight into the trap and create a secondary problem on top of the first one. But today, you're going to do something different. For several weeks now, there had been signals. Not from official U.S. State Department bulletins, not from formal aviation safety channels, just signals that flight operations between the United States and Dubai were facing pressure that was anything but routine. U.S. airlines operating Gulf routes have been cautious, yes, but also increasingly reactive in that approach. Their decisions followed a pattern, a quiet adjustment, an internal review, almost a controlled withdrawal. But what triggered concern among immigration attorneys and travel compliance experts this week was that the pattern suddenly accelerated without public explanation. Analysts who monitor international aviation and its intersection with U.S. visa processing recognize the indicators. The rerouted flight paths, the unexplained schedule compression, the sudden silence from airline communications teams, the abrupt cancellation of code-share agreements on key U.S. Dubai corridors. And when airlines go quiet like this, something loud is usually coming. Early this week, aviation tracking sources detected what analysts described as a multi-carrier operational freeze on direct U.S. Dubai routes, including a simultaneous grounding notice not seen across this many carriers in over 2 years. These are actions that airlines only take when signaling something specific, a safety or security escalation from above, a diplomatic trigger that affects overflight permissions, or a coordinated governmental directive that bypasses standard notice timelines. Observers weren't sure which one applied, or whether all three did at once. But one thing was clear: the operational posture between U.S. carriers and UAE airspace was shifting. And when that happens without a transparent public explanation, U.S. Customs and Border Protection, the State Department, and USCIS all pay attention, because it directly affects who is moving, when, and under what documentation. The travel alert issued by relevant authorities in the past 48 hours was not routine. It was not a calendar advisory. It was urgent, specific, and targeted at a population that often doesn't realize they're in the crosshairs: U.S. visa holders with international travel plans. Immigration attorneys after emergency consultations described this moment as consequential, legally sensitive, and most importantly, a situation where your visa status can be silently affected if you don't understand the rules before you move. Disrupted international travel is not just an inconvenience for visa holders, it can become an inadvertent violation. And when that happens without any intent on your part, the burden of proof still falls on you. But your protection only works if you know the rules before the disruption reaches your door. Today, multiple sources confirmed that the Dubai flight suspension directly impacts U.S. visa holders in ways that most travel news coverage is completely ignoring. If you are an H-1B, F-1, L-1, or O-1 visa holder, or anyone on a non-immigrant status, and you are currently in Dubai, your re-entry timeline has just become a legal variable. They are tracking overstays triggered by disruption-related delays. They are flagging re-entry attempts that fall outside approved I-94 windows. They are reviewing cases where travelers departed the U.S., encountered a flight suspension, and then re-entered through alternate routing without notifying USCIS or their employer's legal team. This wasn't symbolic policy enforcement. It is active, real-time, and being applied to people who had no idea this was happening. And that's what makes the alert so urgent. Let me break down exactly what this means for you. If you are currently in the UAE and your return flight to the United States has been canceled or suspended, your first call is not to the airline. Your first call is to your immigration attorney. or at minimum, your employer's HR and legal team if you are on a work visa. The reason is critical. Your U.S. visa and your I-94 are two different things. Your visa allows you to seek admission. Your I-94 governs your authorized period of stay after admission. If you exited the U.S. on your valid status and a suspension now prevents your return within the window that aligns with your employer's expectations or your academic calendar, that creates a paper trail. And paper trails, when they involve USCIS or CBP, rarely disappear on their own. There is a second layer here that almost no one is talking about. For F1 students specifically, an unexpected delay in returning to the United States can trigger a status complication with your designated school official. Your DSO needs to be notified within a specific window if your return is delayed due to circumstances outside your control. A flight suspension qualifies, but only if it is documented, reported, and handled correctly. A student who goes quiet and then shows up to campus 10 days late without a paper trail is not protected. A student who notified their DSO, preserved their airline cancellation records, and rebooked through documented alternate routing, that student has a defensible file. That difference matters more than most people know. For H-1B workers, the concern runs parallel. Your employer is your petitioner. If you are stranded outside the United States due to this suspension, your employer's legal team needs documentation that this was an involuntary delay. Without that documentation, you are simply absent. And in an environment where USCIS is scrutinizing employer compliance, an unexplained absence of a sponsored worker is not something any employer wants sitting in a file. Get the cancellation notice from the airline in writing. Get the rerouting confirmation in writing. Send it to your HR contact the same day. Do not wait. There is also a concern for green card holders, lawful permanent residents, who may be in the UAE right now. If your trip has already extended beyond 6 months, this suspension may be pushing you closer to a timeline that CBP officers scrutinize at re-entry. A trip that was supposed to be 3 weeks and is now approaching 2 months due to flight disruptions starts to raise questions about your intent to reside permanently in the United States. The defense exists, but it requires documentation, a clear narrative, and in some cases, a returning resident visa or legal consultation before you attempt re-entry. Do not assume your green card is a blank pass if your absence has stretched far beyond what you originally planned. For families with mixed status, one person on a visa, one on a green card, children who are U.S. citizens, the layered implications of this suspension require individualized strategy. What is safe for one family member may not be the correct move for another. A U.S. citizen child can return anytime. Their parent on a visa cannot necessarily follow the same timeline without first verifying their I-94 integrity. Travel decisions for mixed status families should not be made in airport lobbies under time pressure. They should be made with legal guidance, and they should be made before you book the next available seat on the first alternate carrier you find. As this situation continues to develop, more details will emerge about what triggered the suspension, when full operations will resume, and whether additional routes or carriers will be affected. But one thing is already clear. Knowing this right now doesn't make you a criminal. It makes you smart. It means you are prepared. It means you are protecting your family. Share this video with every visa holder, student, worker, and immigrant family you know who has traveled to Dubai recently or has plans to do so. It might save their status one day. Subscribe to Visa Status Radar for more protection. We protect you with real information as the next phase of this situation unfolds.